The people that are accustomed to a particular treatment style are going to be required to change their treatment method, not because they've done anything wrong and not because their ailment is altered, but because the methodology of delivery is changed. Prairie Plant Systems is not sufficient, or any organization is not sufficient to satisfy the Michigan market if they're only producing one strain. I'd also like to dispute his statement that marijuana is not medicine unless it's been through the Prairie Plant Systems testing procedure. Here in Michigan, we've had a medical marijuana law for 5 years. Our Constitution says that marijuana is medicine. It was when we passed the law, and it will be right up until the time the Paracones and the Prairie Plant people take pharmacies over with their product. Marijuana is medicine in Michigan, and that's written into our law already. It's not in debate, and his analysis is incorrect. I'd also like to remind everybody that if the testing system that they have exceeds Federal Drug Administration standards or predicted Federal Drug Administration standards, then if it's more strict, why would we go with a policy that's more strict? That creates additional charges for the product, it creates additional cost for patients. Oftentimes patients are financially disadvantaged due to their illness. Additional costs are not a positive. There is nothing safer than growing your own tomatoes. I think we'd all agree with that. We hear consistently stories about E. coli in the food that we eat, listeria, foreign objects, bacteria. When you grow your own, regardless of what it is the safest way to eat. It is much better to go to your garden and pick a tomato for your dinner that evening than it is to go to the grocery store and pick one that came from California or Ecuador. The same scenario applies to the production of cannabis. The safest way for cannabis to be produced and utilized by patients in Michigan is giving them the option to grow their own. Not only is it safer from a contaminant perspective, it's also safer from a dosing and from a specific illness issue. There is no substitute when it comes to safety to being able to produce your own, and this particular bill does not allow for self-cultivation. Commercially produced foods oftentimes lead to illness and sickness. There's absolutely nothing to lead us to believe that commercially produced marijuana would not do the same thing as well. I'd also like to mention that Mr. Paracone said there were some issues regarding the Prairie Plant marijuana that's produced in Canada. He's referring to the issues expressed by the Canadian government. I can speak to the issues expressed by the Canadian patients. The cannabis being produced is subpar, it is sub-quality. It does not have the consistency or the constitution of the system of the cannabis that they're used to having. Untested, unregulated cannabis has never killed anyone. We've been in Michigan for 5 years now with the Medical Marijuana Act, which, as you all mentioned earlier, does not require testing, but yet there's no deaths. It doesn't require testing, but yet there's no illnesses. Some of the issues that are being raised here are smokescreens, and they're really not germane to the situation that we find in the state as it is. I'd also like to express some concern regarding the fact that the bill that we have in front of us offers looser regulations than the Medical Marijuana Act does itself. It provides fewer restrictions than the MMA does. For example, in the Michigan Medical Marijuana Act, according to the bills passed in 2012 and signed into law by Governor Snyder, you have to have a prior relationship established between the doctor and the patient, but that's not included in the Prairie Plant bill. There has to be a bona fide doctor-patient relationship. There's no restriction as far as the amount of marijuana that can be contained or owned by a particular patient. In the Medical Marijuana Act, it very clearly delineates 2.5 ounces, but there's no such restriction that's articulated in here. There's no restriction articulated on the amount that's being able to be grown by these potential licensed facilities. There's no restrictions whatsoever or regulations contained within the language of the bill to control any of those actions. That's a concern. Another concern is that the bill that we have before us allows law enforcement to get access to the patient's illnesses, symptoms, conditions, and the physician's name that recommended that. I have yet to have anyone articulate to me why a police officer at the roadside would need to know whether I have cancer or leukemia and how that would assist my legal scenario when faced with that problem. The state will potentially license the marijuana production facilities, which are in the bill called pharmaceutical grade cannabis license facilities, which would exclusively manufacture, cultivate, and test the cannabis, and no distribution of cannabis would take place from those facilities directly to patients, therefore creating several middlemen in between, which again increases the cost and decreases the availability. All cannabis must be sold from the cultivation facility directly to a pharmacist. Local communities could not refuse to accept a cultivation facility in their area. I'm quoting now directly from the bill language. A local governmental unit shall not enact or enforce an ordinance regarding pharmaceutical grade cannabis licensed facilities. You are protecting these facilities from local control and local option. The Prairie Plant Bill would create a parallel registry program similar to the Michigan Medical Marijuana Act, but it predates on the Medical Marijuana Act. In other words, you cannot have dual citizenship. We have, as you mentioned earlier, 180,000 people registered in the Michigan Medical Marijuana Program. Each and every one of those people that enrolls in the pharmaceutical grade cannabis program would diminish the number of enrollees in the Michigan Medical Marijuana Act. So the statements that we're seeing here, or that we're hearing, that this bill will not affect the Michigan Medical Marijuana Act are false. It's not correct. It also, the bill that we have before us, does not allow for pediatric cannabis use. Pediatric cannabis use is allowed under the Michigan Medical Marijuana Act, but if you enroll in the pharmaceutical grade bill, then children are not allowed to receive therapeutic cannabis for use, regardless of how many physicians give their recommendation for that. And it also allows for the creation and the distribution of synthetic marijuana. Now, Senator Hildebrand stepped out of the room, and I wish that he was here, because Senator Hildebrand authored a bill which was passed in 2012 and signed into law by Governor Snyder, which specifically outlawed synthetic cannabinoids. You know them as K2, spice, bath salts. In the creation of that bill, Senator Hildebrand created 127 lines of language. This is what Governor Snyder signed into law and said he was proud to sign into law because it protected children. This is what those 127 lines of language are reduced to in your new bill. 4 lines. This protects children. This leaves children vulnerable. I hope after my comments that Senator Richard would articulate why it is necessary for us to eliminate all of the protections contained within the synthetic cannabinoid bill from 2012 and why it was essential for those portions, for that hugely significant portion, to be deleted. I'd also like to say that the creation of small business in Michigan was one of the positive results from the Michigan Medical Marijuana Act. Every community that you visit has a hydroponic store in it, an indoor gardening store. They've popped up in all 83 counties simultaneously as soon as the law came into place. They supply the indoor cultivation market. They supply the people who have cannabis tested through iron labs. It's a network of small businesses that's existent. By introducing a large commercial operation, which would take place at the expense of small businesses, we're counterproductive to the economic success of our state. By confining the economic success to 6, 8, 10 large cultivation facilities, we've ignored the small business opportunities in all 83 counties, and we've also possibly destroyed some of the successful small businesses that have existed for 5 years. There are so many issues with the pharmaceutical grade bill because of the nature that it has. It deserves a full and robust debate. It deserves the full examination of not only just the Senate, but of everyone in this room, of all of the people that have been involved in the program for 5 years. And this bill was introduced to the Senate 5 days ago and rushed to a committee meeting, which we only found out yesterday, which we only found out because we pay attention to the internet and to the legislative schedules. Senator Richardville, I think we can do better, can't we? Instead of just meeting the minimum time requirements listed under law, could we not give greater notice? Could we not have a second hearing instead of just a single hearing with a vote? Could we not have an expanded dialogue and debate on this issue? It doesn't serve.
We're going to recess.
Check that.
Come on out here.
Whoa! Whoa! We just called you in the parking lot, man.
Mr. Thompson. You asked for 5 minutes, I'm taking about 12, and I just had to go to the restroom, I'm sorry.
Actually, I'll conclude my remarks and take any questions that are available.
Senator Vico.
Thank you, Mr. Chairman. Thank you for your testimony. A couple of things I just had some questions about. You stated there's no illnesses, no deaths from the use of marijuana. Is that because there's just not a checkoff on the test certificate?
No, sir. You could be assured that prohibitionists would have portrayed or paraded any death from marijuana a long time ago if there was one. People that have stood in opposition to marijuana rights have been searching for the holy grail of a death from marijuana and have been unable to find it. There simply is not a lethal dose of cannabis. I know that Mr. Perricone, did you state that you're a physician, sir? You could probably
hold on.
probably confirm
Direct your
that.
comments here, okay?
Fantastic, sure. I don't think we have a physician in the house that could potentially testify to that, but
Except for the bill sponsor.
I'm sorry, I apologize, Senator, that's my mistake.
And how is your product now taxed?
I'm sorry, sir?
How is your product now taxed?
Well, it's not my product, it's,
The product.
the product is not taxed currently. And I don't believe there's a proposal inside here to tax it either.
Mr. Chairman, is it, can I check?
I'm close to it. Easy, okay?
And then you mentioned about protected facilities. My understanding now under the Medical Marijuana Act now, if there's a person who has a growing card, their facilities are protected as well from intrusion. So I'm a little bit concerned of where you come up with having, if these are commercial facilities, somehow they're given extra.
There are no facilities to manufacture cannabis. Cannabis is manufactured in people's homes in Michigan. There is not a commercial distribution model yet.
My understanding is that if they have the medical marijuana card and they're a provider, their facilities are protected.
Protected from whom, sir?
No, not search and seizure or other things like
That hasn't been the case, sir. That's not been the case at all in Michigan.
Legally, it's true.
As you can hear from the people behind me.
I thought people would be a little more mellow than this. I mean, come on, just a little bit. Come on.
People go to jail over this.
Every day. Mr. Chairman, I have a further question. Help me, because this actually happened in my county, where we now have some unintended consequences from the recent law, and I believe the people of Michigan have spoken, they want to have it available. We have had an incident where someone's property was seized, their plants were seized, because there was some confusion over the issuance of the license. The person went to jail, thing was rectified, they found out he did have this proper identification. He received his property back.
Did he receive the marijuana plants back?
He did, and they were dead. Because the police don't have any way to take care of them, understand? And so my point is, we've created other issues for which we think we could be better suited through controlling it as a controlled substance. So whether we agree or disagree on that, I think we've created a whole series of other things that have not been helpful to your cause. And I would say that if the people of Michigan, including Ottawa County, which I represent, who voted for it, want to do it, they believe they were getting something pharmaceutical that would help grandma with glaucoma. We created a whole series of other issues which we need to address as well. So thank you for your time here today.
Was that a question? Am I able to respond to that?
I don't know, are you?
I would like to be able to. Certainly, I think grandma is receiving palliative benefit for her glaucoma already. The protection that we're looking for is a protection from law enforcement. You have letters there from Oakland County Sheriff Michael Bouchard. Oakland County is by far the most restrictive county in the state regarding marijuana consumers, marijuana growers, people that are legally registered. In fact, there are people in this room right now behind me that have been through the legal system in Oakland County for legally possessing and legally cultivating cannabis as licensed by the state.
My point is, law enforcement is asking for a way for this, so they don't have to intrude on what people are doing in their homes. They really don't want to do it. They don't have time to do it. They don't have time to do it. They don't want to do it. Okay? We actually want our police to respond to people that are doing something really, really bad. And if this is what the people of Michigan want, the police don't want to interfere with that. I fully believe that. So that, I don't believe that's their intent, and I don't believe if it's gone that way, I can't address any of those concerns that your friends that in the crowd are having, but we're going to find a way to do this the right way, and I hope that's a good step towards it.
Senator Bakoff, what you just suggested to me is that law enforcement would prefer not to allow home cultivation of cannabis, and they would prefer to have cannabis cultivated only in large centers, simply because it's easier for law enforcement to do their job?
No, that's not what I said.
I apologize, then could you clarify for me, please?
They don't want it. They don't want, if the FedEx man sees somebody growing something in their house, they don't want to have to respond to that because those folks are licensed to do that. They don't want to. They don't want to interfere with that. They don't have time to do it. We want them to do other things.
But this bill doesn't eliminate that option, though. Because home cultivation still exists, what you just stated as a problem is not rectified by the legislation before us.
Thank you, Mr.
Is there anything else?
I would appreciate it if you'd help us figure out why you eliminated so much of the synthetic cannabinoid language that was contained in 2012.
I'll let you know. I got other things and other people that I have to talk to before I answer your question. I'll get to it though. But your comparison is a marijuana plant for medicinal purposes to growing a tomato plant at home. Is that how you started your testimony?
That was simply a comparison to illustrate the evils contained in commercial. There's no yes or no answer to that question, sir.
Thanks. You can be
Thank you.